defendant to divide a
Yo. Y'all ain't gonna believe this. I dropped the ball. I'm so focused on the NFL draft tonight that I didn't realize they did it again. These sons of, they did it again. They're going live on the trucking bill in the Senate right now, on the Senate floor. I'm gonna hop on here. I'm gonna get the live stream going. Didn't get any notice. Legislature didn't tell us we were going to be hearing this today. Wish I would have known about it. Would have gotten everybody set up. Going to have the live stream up and firing. Probably not doing any commentary, but I'll have it up and running in case anybody wants to watch it. They did it again. They're going live on the trucking bill in the Senate right now, on the Senate floor. I'm going to hop on here. I'm going to get the live stream going. Didn't get any notice.
Commercial motor vehicle collision trial into two parts, with the first part limited to evidence about the cause of the collision and the plaintiff's compensatory damages, and the second part focused on punishment of the defendants, if appropriate, through awarding punitive damages. HB 19 also would have codified what is known in the legal practice as the admission rule. The admission rule, which has been used in Texas courts since a ruling in the 1961 case of Patterson versus East Texas Motor Freight Lines, held that if an employer defendant admits that its employee was working in the course and scope of employment, what is called respondent superior, at the time of the alleged incident, thereby accepting liability for the employee's alleged errors if adjudicated as such, then the plaintiff cannot bring claims that the employer defendant was negligent in entrusting a vehicle to its employee driver. Since the employee or the employer has already committed to taking responsibility if their driver was found to be at fault, then only evidence related to proving who's at fault for the collision would be admissible. The admission rule puts plaintiffs and defendants on an even footing to present their case, helping reduce trial times and alleviate congestion in courts so that legitimate lawsuits can move forward quickly in a fair and responsible manner. An amendment to HB 19 created unnecessary exceptions to the long-standing admission rule, which has allowed plaintiff attorneys to introduce into the first phase of a bifurcated commercial motor vehicle collision trial evidence of the employer defendant's negligent entrustment, even after the employer admitted the driver was on the clock, essentially dragging out the trials and defeating the purpose of the bifurcated trial structure. Committee Substitute Senate Bill 39 seeks to make commercial motor vehicle collision lawsuits more consistent and uniform by repealing those exceptions to the admission rule that were amended onto HB 19. The removal of the exceptions will appropriately codify the admission rule, fully incorporating the long-standing case law used in courts for decades in Texas statute. During the process of the committee work we did, after hearing concerns during testimony, the bill now also explicitly specifies that a plaintiff is not precluded from pursuing causes of action such as negligent maintenance, negligent loading, negligent repair, or any other similar claim in the first phase of the trial. These causes of action are unrelated to the employee's conduct and are therefore unaffected by the admission rule. Members, this bill only affects the first phase of commercial motor vehicle collision trials in the event that the employer utilizes the admission rule and confirms or admits, as the admission rule implies, that the employee was operating within the scope of their employment. If a company decides not to utilize the admission rule, then all evidence of negligent entrustment is admissible throughout both phases of the trial. Nothing we are doing here today affects the ability of plaintiffs to seek and be awarded punitive damages against defendants whose conduct deserves such. With that, Mr. President, I move suspension.
From me. He didn't want the world to know. They didn't want the public to hear about this.
Senator
bill.
Johnson,
You know what? I think I might
your
jump
light's on.
here a little
For what
bit.
purpose?
Question of the author.
Do you yield?
Yes, Mr. President, I do.
Join me in
To
the live
clarifying
stream.
question,
We'll
Senator
chat
Birdwell, I
about
know
this
you've worked
bill.
hard on this.
It's some straight BS, man.
Claims for direct negligence against a company under a different section, the prior section 72.053, are unchanged by this bill, and evidence related to those claims would still be admissible in phase 1 of the trial, correct? Is that your understanding?
There was a couple of words you said at the beginning of your statement that I did not get clarity
Maybe
on.
you
I've
should
got my
understand 'em,
hearing
bro.
aids and my microphone maxed out, but you turned your head away from the microphone a bit. So would you repeat the question?
Yes, sir. I just want to make extra clear that the changes to section 72.054 in your bill do not in any way affect the right of a plaintiff to present evidence under the prior section, 72.053B,
That is correct.
and that evidence brought then will be submitted to a jury.
Say that again?
And that the evidence that is admissible under
This homeboy don't even know what he's talking about, man. I'm so sick of this crap. I'm so sick of this crap.
72.053 can be admitted to the jury. Nothing in your bill
That's
precludes
correct.
that.
Right. Let me read that 72.053B. In a civil action under this subchapter, evidence of a defendant's failure to comply with a regulation or standard is admissible in the first phase of a trial bifurcated under section 72.052 only if, in addition to complying with other requirements of the law, and then it says the evidence tends to prove that failure to comply with the regulation or standard was a proximate cause of the bodily injury. This bill does not affect that section.
Thank you for that clarity, Senator.
Thank you, sir.
Thank you, Senator. Senator Gutierrez, what purpose?
A few questions, Mr.
Do you
President.
yield?
Yes, Mr. President.
Thank you, Senator Birdwell. I have about 5 questions with some subparts.
Yes, my boy.
It's true that under SB 39, if the employer admits that
This is my boy right here. I love this man. I love this man so much. He's the best. He's the best.
the driver was acting within the scope of their employment, then the plaintiff cannot pursue a direct negligence claim against the trucking company, such as negligent hiring, training, or supervision, correct?
Because that is correct, because the company, in admitting that the driver is in the scope of their employment, means that they cannot be sued for negligent entrustment because the company has agreed and said, we have hired that individual and he is working in the scope of his employment.
Can you think of any other employer that cannot be held liable for negligent hiring, training, or supervision, or any other profession out there?
Not to my knowledge, and I do not believe your question correctly portrays the bill.
No, your question
I'm not,
doesn't betray the
I just,
bill. That's a-
it's a simple question. I'm just wondering if you can think of anybody,
No.
any other profession. Thank you. Is it true that under 39, that plaintiffs can only present evidence of violations? I'm sorry, I got distracted. Everything's okay up there. Is it true that under 39 that plaintiffs can only present evidence of violations of trucking regulations if and only if it is independently admissible and also the proximate cause of the injury.
Ooh, sneaky,
My
sneaky.
answer
They
would be
tried
the
to
same
get one
thing that I
past us,
just
y'all, but
read
we run
in
it.
72053, which is
my boy's about
unaffected
to
by my
pop up
bill
right now.
that I gave Senator Johnson.
The hero we
My
need.
answer would
Not
be the same
Birdwell,
to you
you're
for
not a
that
hero, you're a
question.
clown.
And so here's
There's my
the fourth
boy.
question with a lot
There
of
we
little
go. Let's
subpart
go.
scenarios. I'll try to be very clear. In the first phase of commercial trucking case, unless it's admissible under another law and is also the proximate cause of the injury, a plaintiff cannot present evidence that the driver was not licensed, correct?
The question before us is negligent entrustment. The admission rule means that the company is admitting, that's why the word admission is used, that the company is admitting that that driver is working in the course and scope
Why do you need the
of
rule then?
employment.
Why do you need this rule?
That,
This rule is not
Okay.
benefit anybody, man.
I'll go to my next question, if that's your answer. That the driver had been disqualified from driving for violating trucking regulations, that wouldn't be allowed, correct?
Based upon what I read to you from 72053, it says in a civil action under this subchapter, evidence of the defendant's failure to comply with a regulation or standard is admissible in the first phase of a trial bifurcated under section 72052 only if, in addition to complying with other requirements of the law, the evidence tends to prove that failure to comply with the regulation or standard was a proximate cause of the bodily injury or death. That is unaffected by this bill.
Whether or not the driver was prohibited from driving, that wouldn't come into play either, unless it was admissible under some other rule and was a proximate cause of the injury.
Could be admissible, based upon what you've said, could be admissible under 72053.
That's right. Well,
Whether or not the driver had been medically certified to drive would not be admissible unless it was some other way and also proximate cause, correct?
If the company uses the admission rule to say
Yeah,
that the
that's right.
driver is working
That's
in the
right.
course and scope of employment,
okay. Okay.
then that is not admissible in phase one. But if the driver is found liable, then that can be considered in phase
Right.
two. If, Senator,
Why do you need that?
the company does not
Why do you
admit
need that?
that the driver is working in the course and scope of their employment, then negligent entrustment is eligible in phase one.
Right. And I have a whole list of these, and I'm not going to belabor the point.
Right, because
But I
you
will
don't
add
need it.
one more,
This is so
and then I'll get on to
stupid.
my fifth question, if that's okay with you.
I'm at your discretion answering your question, Senator.
Thank you very much. Whether or not the employer drug tested the driver wouldn't be admissible under 39 if that was not the proximate cause of the injury or the accident.
If it did not apply under 72053, which we do not amend and remains in place,
And so my last and fifth question would be an assessment of what you think happens once we make trucking companies no longer accountable for their negligence in hiring, training, or supervision of their drivers. Do you think our roads will be safer or less safe?
that question is not germane to what I'm doing in this bill, Senator.
What's the point of the bill then, bro? Then what's the point of the bill, man? Some bullshit, man. Some bullshit. Let's keep going.
I'm doing is ensuring that the trial process is bifurcated in phase one. Evidence of the specific acts of that accident are phase one. Phase two, if phase one is adjudicated as liability to the trucking company and punitive damages are awarded by that jury, it's done in phase two. So I'm ensuring that the facts of that
that out of here.
accident are phase one, and then any punishment is phase two.
Well, respectfully, and I was going to end there. However, you said that the question wasn't germane, because which again, I guess by saying that, you're suggesting that this bill isn't about accountability and it's not about safety, but it's about what happens at the courthouse.
It's about having both parties have a fair trial. By having the bifurcated structure, according to the case law from 1961, we are putting that bifurcated structure back into the courtroom.
You would agree with me that it is incumbent upon all of the people in this building to ensure that our roads are safe and that people, including trucking companies, do the things and put the necessary measures in place to make sure that their drivers are acting safely. You would agree with that statement, correct?
Yeah, I want my roads to be just as safe as every other Texan.
But because of our separation of powers that we not only have in this state and we have in the United States, it's really part of our doctrine. Sometimes things get by. You would agree with the statement that sometimes those courthouses down the street and others like them across this state are here to find the temporal truth. The temporal truth as to what happened at that accident, who is responsible, and who is to be held accountable. You would agree with that, wouldn't you?
I agree that I'm trying to have a fair, bifurcated trial structure that if the truck company admits that the driver isn't working in the course and scope of their employment, that respondent superior status I mentioned, that in phase one, the status of the driver's employment is not subject to the additional findings that I think you seek here, unless in section 72.053, if there's something related to the, I'll read it again, in a civil action under this subchapter, and we are not changing this section, of a defendant's failure to comply with a regulation or standard is admissible in the first phase. So if what you've just said as the proximate causes are in fact the proximate cause, then it would be subject in phase one, because we do not touch 72053. But if it's not the proximate cause, then in phase one, with the bifurcated structure, having established respondent superior status and saying that the driver is in fact working in the course and scope of the employment of the company, then the question of negligent employment is not subject to question in phase one. Liability could still be found, and in phase one, the truck company could still be found liable for the actions of other items, other negligence. And then phase two, you have the compensatory and the punitive damages in phase two. We are not touching that. We are simply establishing the bifurcated structure of phase one is the finding of fact, and phase two is adjudication of punishment if appropriate. And when the trucking company says that my driver is working in the scope of employment, the respondent superior status.
What the hell are you talking about, bro?
Senator,
Yep, go ahead.
I respectfully submit to you that what we're doing here is we're limiting accountability of trucking companies. I respectfully submit to you that we're limiting people's access to the courthouse, and reasonable minds will differ.
Well, I hope you think I'm a reasonable mind, because I do differ. I don't think we're limiting people's access to the courthouse.
But your supposition that people aren't, or companies aren't getting a fair trial, I would respectfully argue is wrong, sir. I think that what
we'll
we're
agree
doing.
to disagree, Senator, and I appreciate the respectful manner in which you've exchanged with
Well,
me.
I'm trying to be, but if you just please not speak over me so much. Thank you, Senator, for this bill. Like I said, I respectfully disagree with it, and I think that we are limiting access to the courthouse, and one day, one of your constituents will be maimed by someone, by another one of your constituents. And that person won't be able to get access.
That's right.
Because you've limited a whole bunch of claims that maybe his employer would have been responsible for. Appreciate
That's right.
your bill. I'm not for it, but I understand what you have to do.
That's right. I understand what you have to do because you're bribed. Because you take bribes. Shut up, Dan Patrick. You suck.
To ask questions of the author.
Do you yield?
Yes, Mr. President.
Thank you so much, Senator Birdwell. And most of my questions were answered. My concern between the prior
clown,
section,
dude.
72.053.
Oh my God. Is that
which
Cruella
is-
DeVille? Is that Cruella DeVille? My God, I love that suit. Sarah Eckhart, she's great. I like this. I like this lady right here. She a good senator.
Rid of section C of 72.054. Do you see that there could be a gap between what is a regulatory standard and what is negligence by the employer that would be
Nothing wrong with dropping some fashion in the Texas Senate. Lord knows the male senators don't. They wear the same blue tie, blue suit. Boring ass crap. They need to talk to my boy Jay Murray, get some cool suits. Jay Murray got cool suits.
important evidence in the first phase?
No, because what that paragraph C is a restatement in
I call
state
client. Be
law
right back.
of federal regulatory requirements. So in removing that, to help clarify the chapter, those federal regulations still apply. They're just not restated in state law.
Not all of what's in C is necessarily a regulatory standard. For instance, the regulatory standard with regard to the numbers of hours.
Movers of what, ma'am?
The numbers of hours,
Hours,
continuous
okay.
hours of driving. That standard, there may be negligence that is above that standard that would be useful in the first phase with regard to negligent oversight of the driver.
I didn't catch the question, ma'am. I think you made a statement, but I don't know what the question is.
There could be negligence that is in the category of regulatory requirement, but of course the regulation sets the floor, not the ceiling of negligence. So by striking C on the presumption that all of it would be taken care of in 72.053, we are assuming that the regulatory standard in 053 is both the floor and the ceiling of negligence by the employer.
The federal standards that we take out here are still applicable because we cannot supersede and rescind federal law.
Agreed. Agreed. Thank you for answering my questions.
Thank you, ma'am.
This is a complex area of litigation.
Yes, ma'am. Well, that's why I'm trying to keep the shot group tight.
Thank you.
Thank you, ma'am.
I like how you always bring it back to a shot something. Thank you. Senator Menendez, you want to talk to your neighbor there?
Yes, I'd like to speak to my non-lawyer neighbor who is very adept at these legal bills.
Yeah, he has become very adept. I would agree with you.
Very
Well,
impressed.
you helped put him through law school by just your questions over the last 10
Tell
years.
you what.
Do you yield? Do you
Yes, sir.
yield?
Mr. President, I do. To my neighbor. Yes, sir.
Thank you,
Happy to.
Mr. President. Thank you, neighbor Senator. Senator Birdwell, as you already are aware, Texas ranks #1 in truck crashes in this country. You're aware of that, right?
No, but given the size and the numbers of miles that we have in our state compared to any other state, it would not be that would not be a statistic I would question.
I understand and I appreciate that. So my concern is, being a non-lawyer, I'm not going to get into the chapter specifics. I just want to get into some common sense questions that my constituents might think of and be concerned with. Does this bill not stop claimants from introducing direct evidence of negligence during the first phase of the trial?
If it's negligent loading, negligent maintenance, other elements of negligent that once the company establishes its respondent superior status, those other elements are still subject. If the company does not express respondent superior status, then that would be admissible in phase one.
Okay, very good. So evidence of the trucking company's negligence would be directly related to guilt. Would you not agree?
Well, the facts of the situation would determine that. Remember,
Exactly.
remember the term, the admission rule. Let's not, and I'm not, I want to be, because neither one of us are attorneys here, but the admission rule is used to admit that the driver was working in the scope and course of employment.
Right.
But all too often, we generically hear the term admit in a courtroom proceeding to equaling guilt.
I see.
The company is not admitting guilt that they're at fault in the accident. The company is admitting by the admission rule that that driver is working in the course and scope of employment. Therefore, I'm having a blank on the word now. I used it just a moment ago. The hiring of the driver and the employer by the employer, when they say, I have taken responsibility as the respondent superior, negligent entrustment is not an element of the first phase. If they don't accept admission that it's in the course, then negligent entrustment is eligible in phase one.
So how does your bill change the balance of opportunity to present negligence in litigation of this kind?
Let me give you a more generalized example. It makes phase one have merits on the facts of the actual accident. It prevents, by having the admission rule, it prevents previous citations, previous record from being used to adjudicate guilt in the current accident civil case. The criminal equivalent, I'll give you the criminal equivalent if I may, even though this is not bill is not specific to criminality. If I committed murder 30 years ago, got released after 10 years, I am now charged 10 years later with another murder case.
Right.
Does the prosecuting attorney, or in this case, the plaintiff's attorney in a civil case, get to bring that evidence into trial in phase one and say, we know he committed murder here because he did it 10 years ago? Because what happened 10 years ago is not a fact to who is liable in this accident at this moment. Now, if I'm adjudicated liable for that accident, then in phase two, that history can be brought forward. Just like in a criminal case, if I'm convicted of murder a second time, the penalty can be higher. So if the history is brought into phase two, then that penalty that's punitive can be much greater because of I don't want to use the word habitual, but previous history of that trucking company. But that way, phase one is solely on the merits and the facts in that case, not other cases being brought into phase one.
So I appreciate the answer, but for me, and I think this is the overarching goal, is I think it's super important that the jury is able to understand how the crash happened, all of the facts that may have led to it, in order for them to reach a verdict. And that's what my concern is. Maybe we should leave the option of the bifurcated trial to the judge's discretion. What are your thoughts?
No, because if you leave it to the judge's discretion, remember the judge is not the accused.
Correct.
Because in our judicial system, in baseball, the tie always went to the runner.
Yeah.
So in our judicial system, be it civil or criminal, it always has to operate to the favor of the accused, the same way we did impeachment with Attorney General Paxton. Everything that we did was to ensure he got a fair trial.
Appreciate you taking my questions.
Thank you, Senator.
Thank you, Mr. President.
Members, the vote is on suspension of the rules. Secretary will call the roll.
Alvarado, Betancourt, Bardwell, Blanco, Campbell, Cook, Creighton.
21 ayes, 10 nays. Rules are suspended. Chair lays on second reading. Committee substitute for Senate Bill 39. Secretary, read the caption.
Committee substitute Senate Bill 39 relating to civil liability of a commercial motor vehicle owner or operator.
Recognize on engrossment.
Move passage to engrossment, Mr. President.
Secretary will call the roll when ready. Secretary will call the roll.
Alvarado, Bettencourt, Birdwell, Blanco.
21 ayes, 10 nays. The bill passes to engrossment. And unless you have 4 good friends, we'll stay there.
Thank you, Mr. President. Thank you, members.
Welcome to our guest on the balcony. Good to have you with us today. Senate Bill 1183 by Senator Creighton. You're recognized to suspend the regular order of business.
Thank you, Mr. President and members. The Lone Star card in Texas, members, is the ID card for financial assistance programs across the state, such as the Supplemental Nutrition Assistance Program, SNAP, and Temporary Assistance for Needy Families, TANF. Currently, the Lone Star card is not required to display the recipient's name or photo. This leaves the card vulnerable, for it could also be used by someone other than the intended or approved recipient, which would be a misuse of taxpayer dollars. It would also, through the fraud and the misuse of that card, cost other vulnerable Texans the opportunity to have much needed assistance. Senate Bill 1183 requires the Lone Star cards to display the name and photo of recipients or other authorized persons. The cards will also be required to display a hotline and website for reporting suspected fraud. Additionally, the bill directs Health and Human Services Commission to monitor the frequency with which recipients request replacements of their benefits card and report this information to the legislature each year so we can track the amount of data necessary to make any additional and needed changes in the future. Members, I know how important this program is to all of our needy Texans and vulnerable families across the state. It's so important to make sure that as we work to protect the program itself, as far as eligibility and benefits that are available, we also want to ensure that these benefits actually go to the intended recipients and the children that rely on it, and that it protects our most vulnerable elderly populations as well from fraud and ensures that taxpayer dollars are used for their intended purpose. And with that, Mr. President, I move suspension of the regular order of business to take up and consider Senate Bill 1183.
Secretary will call the roll.
Alvarado, Bettencourt, Birdwell,
21
Blanco.
ayes, 10 nays. The rules are suspended. Chair lays out in second reading Senate Bill 1183. Secretary, read the caption.
Senate Bill 1183 relating to electronic benefits transfer cards used by or for recipients of benefits under certain assistance programs.
You're recognized on passage to engrossment.
Thank you, Mr. President. Move passage to engrossment for Senate Bill 1183.
Secretary will call the roll.